All right, we're here today for a pretrial and a bond violation in this case. What would you like to do, Mr. Burkett?
Well, I would like for you just to dismiss the whole case and everybody go home, but that's not going to happen. Uh, I spoke with the prosecutor several times, and to be really candid with the court, I don't really understand what was happening, what our prior attorney did. But in the meantime, based upon the meeting we had last week, I asked I think she applied to Don's firm. It's my understanding that they've interviewed her and they told me that they sent you a report. They haven't, for some reason, they haven't sent me a report of it, but I was told that they did forward one to you. I also spoke with Mr. Ray from 14B. I'm sorry, Your Honor, were you saying something?
I don't have a report, but you spoke to who?
Mr. Ray from the 14th District Court. I got an email from him saying that he's interviewing my client this week to see if she can get into their program or in-house or you know, on an in-house facility. And I spoke with the prosecutor Friday about how we're going to deal with this. So I guess I was waiting to see if she was going to be admitted to Don's firm or or Mr. Ray said he would advise me this week. But now, in terms of the pretrial, I've talked with my client and I explained to her all of her constitutional rights and she understands them. Because she had, I'm sorry, Johnny, you're breaking. Did you say something?
No, I did not. That's the jail.
Oh, okay. As I was saying, I talked with my client and she does understand all of her rights, but because she has no memory of what transpired, and I don't know what her other attorney had done on the case. I advised her that in terms of the bond violation, based on the reports that I received from the prosecutor and going over with my client, that we'll plead no longer contenders if this honorable court will accept it.
You want to plead no contest to the bond violations, is what you're saying?
Yeah. Yes, no, because she has no memory of what transpired.
Ms. McDuffie, what is your position on a no contest plea to the bond violation? I think we're here for the scram tether violation.
Correct. I know we had discussed that with respect to the actual underlying pretrial. So the bond violation is a little bit different, Mr. Burkett, because if this had been maybe a little bit earlier on and the circumstances were a little different, I don't think I would have necessarily objected. But for this to be the most recent of, I can't count how many individual ones. I know we have 3 or 4 reports. I'll leave it to the court. I'll just say that.
You understand? I didn't get into this case until a few weeks ago, and I would have dealt totally different in terms of a pretrial.
I understand, Mr. Burkett. I'm just on the bond violation, the most recent bond violation now.
So this encompasses the December 31st, 5:26 a.m. tamper that was detected and lasted until 9:35 a.m., 4 hours and 9 minutes, where alcohol was detected. And then December 31st, from 3:49 p.m. until January 1st, New Year's Eve, at 8:57 a.m., where she was tampering for 17 hours and 8 minutes. And then January 6th to January 7th for 1 day and 2 hours where alcohol was again detected. And then January 8th to January 9th for 22 hours and 37 minutes where alcohol again was detected. And from January 10th to January 11th in which, for 17 hours and 42 minutes, in which alcohol was again detected. So you're telling me that she has no recall of any of those incidences?
Tells me she doesn't, and I kind of, and I do believe her, Your Honor.
The only way I would accept that is if she's going to acknowledge that she was drinking to the point of having no memory. We can just have our hearing.
One second. Ms. Clay, did you want to say something?
Yes, we were talking about me not having not knowing about the sock underneath my tether. Is that what we're talking about for all those days and those hours?
No, we're talking about the fact that alcohol was detected.
Yeah, I'm sure it was, but I was at work. I'm sure it was detected a couple of times, but not as far as alcohol consumption. Alcohol detection, yeah, yes, Your Honor.
I don't even know what that means.
As far as maybe I was using perfume, or like I said, I'll be at work 12 hours, hand sanitizer.
Absolutely not will I accept the plea based on that.
Yeah, Your Honor, there's no way.
So, Your Honor, I'm not actually, Mr. Burkett, I needed to know if we were definitely going to go through with the hearing because I don't have, the witnesses here today. In order to do that, I know she had brought up hand sanitizer last time, but when we talked, I was under the impression that she was going to be entering a plea on the underlying case and potentially admitting to the violation. So I don't
I can admit to the violation. Yeah. Well, and also I thought that I was going to be put in inpatient treatment, and I had an assessment. Well, I was on the phone with Amanda. I had kind of Patrick, and he said that he was going to give my referral to Judge Washington. And I had spoke with him on the 16th February, and that's when I got my referral.
What are we doing today, please?
Well, I thought we were going to enter a no contest on this.
I'm not accepting a no contest when she's claiming it was perfume. So she apparently has recollection.
It's been updated or what?
But you remember everything we talked about yesterday and last night?
The other problem I have, Mr. Burkett, is, she's saying she wants to go to treatment, but in reality, she's saying that she wasn't using any alcohol, and this is from perfume. So why would someone want to go to treatment who has actually no admission or acknowledgement of having an alcohol problem?
Yeah, Yana, we discussed that, and she knows she has a problem. I don't know why she's telling you she doesn't have a problem. She knows.
And the letter of
what I'm going to do today, it's in her best interest to plead no to this guy. I understand your position. She definitely wants to go to treatment. She knows she has to go to treatment, and we're trying to get her in a treatment program. And everybody seems to be cooperating with me, but they won't release the reports unless you. That's
not, well, so first of all, Mr. Burkett, that's not how it works. What happens is they interview her, they determine whether she's eligible for treatment. If they find that she is, they send me over a request to release her once a bed becomes available. So one of two things is happening, and I cannot tell you which. Either there is no bed available, or she gave them the same malarkey that she's giving me, and they decided she didn't need treatment, and therefore they're not referring her to treatment. So I can't tell you which of those is occurring.
I have to believe that there were no beds available. I cannot believe she told them what she told you this morning, this point.
Well, if she did, then they would find that she doesn't need treatment because perfume is not a reason to go to treatment.
I believe me, I understand that. But Mr. Rage is supposed to interview her this week, Your Honor.
I understand that. That's for our program here at the Recovery Court. And if she doesn't have an alcohol problem, why would she be in that program?
Ms. White does have a program, does have a problem, and she knows she has a problem. I guess it's hard for her to admit it. Ms. White, you are aware that you have a drinking problem, correct?
Oh, no.
Yes, yes, I do.
And we,
No, no, no,
if you don't
Why
get,
don't I put you in a breakout room with your client so the two of you can talk about what we're gonna do today?
all right.
Thank you.
White, it's my understanding that you're going to enter into a guilty plea as to both the bond violation and the operating while intoxicated, impaired second offense. Is that correct?
Yes,
Please raise your right hand to be sworn, Ms. White. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, ma'am.
yes,
January the 31st at 5:26 a.m., you tampered with your scram bracelet and it lasted until 9:35 a.m. And during that 4 hours and 9 minutes, alcohol was detected.
yes.
I find that there is a factual basis for the plea has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Mr. Burkett?
Yes, yeah.
Ms. White, I'm going to accept your plea. And Ms. White,
Yes,
you had similar issues when you were on probation last time. You ended up, I think, finishing out your term on that probation, and you did some jail time. I
yes.
going on recall, but at that time, I think we tried to get you to see how serious this was and how you have an issue. You're gonna keep coming back here and you're gonna end up in prison, ma'am, if you don't fix this issue.
I understand, Your Honor.
And I'm sorry that you are here. Because otherwise you seem like a very nice person. But you just can't get this under control. And the longer you're in denial over it, the worse your consequences are going to be.
I would like to get it under control.
Well, if they send me the paperwork, I will release you to a treatment.
Okay.
And I pray that you really, really take advantage of that opportunity. Because if you don't, people aren't going to be willing to give you an opportunity.
I understand, Your Honor.
All right, I'm going to schedule you for sentencing. That'll be April 1st, 2024 at 10 a.m. Bond is continued with defendant released to treatment. So you need to keep talking to them about when they can make that happen. I hope you told them the truth, ma'am, because otherwise they won't let you into treatment.
Well,
May I ask a question, Your Honor?
Sure.
So the assessment I did with Patrick, he said that he was gonna send it over, the referral over to me.
They never send me the actual assessment, Ms. Wade. They only send me a request for you to be released to treatment once the bed is available. So
I see, okay.
if they've assessed you and there's not a bed, they're not going to send it to me yet. They send it when the bed is available.
Oh, okay, I see.
Okay?
And Your Honor, just one
Yes.
thing, something that may be causing some additional confusion is that Ms. White's previous attorney, Mr. Lebo, had adjourned a number of times for her to get an assessment, and that was completed. And I think that may be gumming up the works with the understanding of what report is being sent where and for what purpose. So she went to Statman back in December or so. Yeah, December 4th. So we do have that report or that assessment, but I think that may be causing some issues too.
No, I think they do those completely separately. Once she's interviewed in the jail, then if she's deemed eligible through Don Farm or whatever program they want her to send her to, they keep that there at community corrections, but then they send me the request to release her only once the bed is available. So they may not even know about the Statman thing.
Oh no, I meant on the part of Mr. Burkett and Ms. White, that interview that she did may be causing some confusion with what has to happen now.
No, I think he said that she was interviewed by Don Firm.
Okay.
Yeah. Am I correct, Mr. Burkett?
That's what I've been told, Your Honor, yes.
Thank you. So, Mr. Burkett, you might want to call over to correctional services there to confirm that she's been interviewed and is eligible to go to that programming. Okay.
I'm gonna do that.
All
Your Honor, sentencing, will it be on Zoom?
Yes, it will be on Zoom. And if she is at Don Firm, they will bring her on Zoom from Don Firm to be on Zoom. They will put it on Zoom for us. Okay.
Appreciate it very much. Thank you.
Thank you.